As you have heard, I am a judge of the Caribbean Court of Justice, and that's a destination I arrived at quite by accident. Actually, I heard Adrian a short while ago saying that he was intent, I thought I heard, I'm not sure, on being a lawyer at a pretty early age. But I never had the desire to study law. When I was in sixth form in the early 70s, there were these UE scholarships that were advertised, and it was a competitive process. The applicants for the scholarships had to write an exam. But before you sat the exam, you had to indicate your proposed course of study. When I went to register for the exam, I was asked, well, what you're going to study, because we have to indicate on the form. Well, I was completely stumped. I knew I wanted to go away and study. You want to leave St. Vincent and go and study somewhere. But I was doing history, economics, and English at A-levels. And I do have the highest regard for the teaching profession, but I didn't quite see myself coming back home to teach English or history. So I wasn't sure what to put on that form. And the extramural tutor said to me, well, listen, you have to put something. Last year, they started a faculty of law in Barbados, so you could put down law. Well, it crossed my mind when he said that my grandfather always used to say to my mother and to me that there were no lawyers in heaven. So, pondering whether I was letting myself in for eternal damnation, I hesitantly said to him, well, okay, you could put down law. And that was it. Passed the A-levels, passed the scholarship exam, went off to Cathedral, and I fell in love with the law from the very first day. And that love affair has just kept getting stronger and stronger. But I'm really very particularly pleased to be here this evening to participate in this celebration of the 40th anniversary of the ordination to the priesthood of Reverend Monsignor Blackett. I first met Father Harcourt, as I called him then, way back in the 70s. I think he was then the Catholic chaplain to the Cathedral campus of the University of the West Indies. I thought then that he was the ideal chaplain for those times. The students on campus then were, in my estimation, quite unlike those of today, who seem to me to be very preoccupied only with passing exams and quickly getting out of college. Well, we students back then in the 70s, we savored our non-academic university experience. It was as instructive as the academic side of things. We had very strong social consciences that we passionately nurtured alongside a deep commitment to regionalism, which was itself fostered by the University of the West Indies. I believe the students of the 70s were concerned less about our individual possibilities after we were unleashed on the public, and more about the social progress of the Caribbean as a whole. Students, for example, and the world, not just the Caribbean, but the external environment, external to the Caribbean as well. Students were, for example, concerned about the plight of the people of South Africa, of Southern Africa, and especially people of apartheid South Africa. I recall, for example, the African Liberation Day demonstrations that were organized here in Barbados, where we would leave the campus and demonstrate in solidarity with our brothers and sisters in Africa. Father Blackett was not outside this stream of consciousness, and so I put it that mildly, and so he endeared himself to many of us. He was progressive, patient, understanding, and we all had the utmost regard for him. In my own case, he played a very special role in ministering to my older brother. Ronnie was the second to last in my family, I being the last. So he was my closest sibling, about 4 years older than I was. And although I never told him this, I grew up worshiping him. He preceded me to UWI, and in the final year of his medical studies in Jamaica, he was diagnosed with bone cancer. And he continued with his studies. He did his internship at the Queen Elizabeth Hospital in Barbados, with the cancer already beginning, slowly at first, to ravage his body. And it was Father Harcourt who ministered to him as he struggled with his illness, spending many long hours with Ronnie, responding to his spiritual needs. Throughout this ordeal, Father Blackett was such a tremendous source of comfort and support. He became a close family friend and was a frequent visitor to our home when he was in St. Vincent. In particular, he became quite close to my mom because she, as one of the pillars of the Catholic Church in St. Vincent and the Grenadines, naturally shared much in common with him. My father, on the other hand, was a pillar of the Methodist Church in St. Vincent and the Grenadines. Indeed, my parents were held out as a famous example of ecumenism, a living symbol for over 50 years of the truth that persons of different faiths can love and care deeply for each other, both at an individual and at a social level. As I contemplate the mayhem and turmoil in much of the world today, it just seems as though we have regressed. While in the 70s, much of the conflict in the world was rooted in ideological differences, in ideas about the superiority of social systems, whether capitalism or socialism. In today's world, it seems that primal differences, religion, nationality, race, all seem to be taking center stage. Conflict among humankind, contradiction is natural, but it doesn't have to be resolved through war and violence. And indeed, our chances of maximizing our own progress as a human race improve dramatically if and when we can find common cause with neighbors who are of different ilk. And this brings me to the matter on which I would like to say a few words on this evening, namely the Revised Treaty of Chaguaramas, the RTC, Revised Treaty of Chaguaramas, and the jurisdiction of the Caribbean Court of Justice, the CCJ, a court on which I am honored and privileged to sit. At the great risk of boring you, I intend to give you an explanation of how the CCJ functions in what we call the original jurisdiction. The original jurisdiction of the court is to be distinguished from the appellate or domestic jurisdiction, in which, for example, we are the final court of appeal of Barbados. Well, tonight we're not going to be talking about appeals. Our original jurisdiction derives from the Revised Treaty of Chaguaramas, which establishes the Caribbean community, including the CARICOM single market and economy. And the court is really the centerpiece of that treaty, the fundamental difference between CARICOM of old, that is CARICOM before 2004, and CARICOM since the court has been instituted. As the preamble to the treaty states, the CCJ is essential for the successful operation of the CSME, CARICOM Single Market and Economy. The treaty, the Revised Treaty of Chaguaramas, should be seen as a response by CARICOM to the challenges faced by the forces of globalization and liberalization. The treaty is premised on the commitment of CARICOM states to deepen regional economic integration, in order to achieve sustained economic development based on international competitiveness, coordinated economic and foreign policies, functional cooperation between the states, and enhanced trade and economic relations with third states, that is, states outside CARICOM. Now that sounds like a whole big mouthful. Basically what it's saying is that, look, in today's world of globalization, these dots in the Caribbean will completely be swamped and be rendered less relevant than they already are unless they can find common cause with each other, pool their economic resources, and see if through that pooling there is any glimmer of a chance of competing on the international market with the major players that are out there. So this attempt at bringing these islands, these countries together, because we have more than islands, we have Belize, we have Guyana, it represents a critical milestone in what Professor Kenneth Hall says is the path to avoid the looming threat of marginalization. Now, in its original jurisdiction, the court interprets this revised Treaty of Chaguaramas, because a treaty, and I've brought a copy, it's somewhere there, it's a long, long document, 100 and something pages. And because a treaty is a document which is agreed by different states, the language of treaties is almost always ambiguous because it has to please different states with different agendas. So it admits, the treaty, it admits of different interpretations. And there is need for a single body that will give an authoritative, a definitive interpretation of the language of the treaty, an interpretation which every state pledges itself to abide with, to comply with. The statutory framework, the legal framework that supports the court is the treaty itself, the terms of the treaty, what the treaty says, and in particular, the articles that run from Article 211 to 222 that speak directly to the work of the court. The other articles would speak to things like freedom of movement, freedom of the movement of goods, freedom of the movement of capital, competition among states, and so on. So you have, on the one hand, the treaty provisions. Then there is the agreement establishing the Caribbean Court of Justice, which is another agreement entered into by the states of CARICOM to establish the CCJ. And incidentally, in that agreement, all of the states except Suriname, Grenada, Antigua, and St. Vincent and the Grenadines, all of them had agreed that they would stop sending their appeals to Britain and instead send them to the Caribbean Court of Justice. Happily, Barbados was one of the first countries to comply with that treaty obligation, so to Guyana. But the two most economically developed countries in the region, Jamaica and Trinidad and Tobago, are yet to comply with that solemn promise that they made in that agreement. But we're not talking about that tonight. So you have the agreement setting out the court, establishing the court. You have the Revised Treaty of Chaguaramas. And then you have, as a third source of the jurisdiction of the court, agreements, resolutions, decisions which are made by the Conference of CARICOM heads of government and other organs of CARICOM. And we will get back to one of the decisions which the Conference of Heads of Government made in a little while. And then fourthly, you have the original jurisdiction rules of the court, which are made by the president and the judges of the court. The president and the judges, they make these rules which basically outline the procedures for accessing the court and for conducting litigation in the court. So those are the documents which underpin the remit of the CCJ. Now, in its original jurisdiction, the court delivers a single judgment, which is very different from appellate courts in the region, where each judge is entitled to follow his or her conscience and to give his or her own opinion on the legal dispute at issue. Well, we took a decision, and when I say we, that is the judges of the court, that we would give a single judgment because we thought that it was important that the court speak with one voice when we were giving an opinion on the interpretation and application of the treaty. We did not want to run the risk that, for example, in a dispute ostensibly between Barbados and St. Vincent and the Grenadines, for example, that people might read into the circumstance that the judge from St. Vincent and the Grenadines sided with the position advanced by St. Vincent and the Grenadines, while the judge from Barbados sided with the position of the judge from Barbados. But that instead, we would give a single judgment which will establish that the court as a whole considers that a particular interpretation that we have agreed upon is the definitive interpretation, and the judgment that we give is the definitive judgment that the court wants to project on any particular issue. So we have no dissenting opinions. And this means that as judges, after each case, we have to strive for consensus, if that is possible. And that is sometimes problematic because adjudicating legal disputes, especially at the highest level, is not about right or wrong, or black or white. The law always admits of a host of nuances because legal interpretation is as dynamic as society is. You put the 10 best judges in a room and you present them with a single legal dilemma, and it's possible that you could get 10 different shades of opinion. And that is why judges render a judgment, an opinion. They don't provide a mathematical answer to a problem. So in our original jurisdiction, the judges hearing a case must therefore seek to meld their differences, if that is possible. And if it is not possible, then the minority must submit to the views of the majority, which is why the treaty also requires that we sit in an uneven number. You sit 3 or 5 or 7, as the case may be. Now, CARICOM states recognize the jurisdiction of the court, and this is a treaty obligation, as compulsory, ipso facto, and without special agreement. That's the way it is put in the treaty. In other words, a state cannot choose to ignore a suit brought against it on the basis that it refuses to recognize the jurisdiction of the court to adjudicate on this particular suit. What a state may do is to come before the court and to submit, to argue, as some states have done, that on this or that point, the court is unable to take a position one way or another, or indeed that the court lacks jurisdiction. But in that event, it is the court itself that determines the issue. The revised treaty clearly says that in the event of a dispute as to whether the CCJ has jurisdiction, the matter is to be determined by the decision of the court itself. So, what kind of disputes can be brought to the court in this original jurisdiction? Well, there are 4 types of matters which can be heard by the court. Firstly, you have disputes between the CARICOM member states, between Barbados and Jamaica, and between Trinidad and Guyana, as the case may be. Any state can bring an action against another state for an alleged breach of the treaty. Or you can have disputes between the member states and the community. A state can bring a case against the Caribbean community, perhaps claiming that the community was unfair to it in the manner in which it laid down a particular rule or whatever. But that's another kind of dispute that the court can hear. Thirdly, the court can hear what is called referrals from national courts of any member state that is a party to the agreement. And I will tell you a little bit more about a referral, what a referral is. And fourthly, the court can hear applications by private entities. And when we say private entities, we mean individuals, human beings, or companies, corporations. And there is a special provision that allows for private entities to bring proceedings before the court. Up to this point, except in one case, all the matters brought before the court have been applications by companies. No state has ever sued another state, although Jamaica did seek and obtain permission to intervene in the Shanik Mairi case. This reluctance of states to sue each other is not surprising. That is also the case in Europe, where you have a regime that is not very dissimilar. The treaty actually contains a raft of measures, alternative to litigation, that can be utilized by states when they have a difficulty with each other. And these measures would include good offices. They will get some individual or group of individuals that they respect and use the good offices of that individual or that group of individuals to manage the dispute that they have. Or the states might engage in mediation, or they might simply enter into prolonged consultations with each other. So states try to avoid suing each other, especially states that form a community, because of course there are such various levels of interaction and cooperation that they enjoy with each other that they don't particularly like seeing each other in court lining up against each other. Now, I spoke about referrals from national courts, and what that means is that domestic judges and magistrates are required to refer to the CCJ any issue that comes before them whose resolution concerns the interpretation or application of the treaty. So if somebody, for example, begins an action in the High Court in Barbados, and it turns out that in the course of that action, it seems as though one of the issues that is raised concerns the interpretation of the treaty, the Revised Treaty of Chaguaramas. Then the judge is required to hold up, to stop, and to define that issue and send it to the CCJ for a determination before they can continue with the action. And the reason for that is fairly straightforward. One of the goals here is to ensure uniformity and certainty in the application, the interpretation and application of the treaty, so that we don't want that a judge in St. Lucia might interpret the treaty in one way, and a judge in Guyana might interpret the same area of the treaty in another way. We want a single, a uniform interpretation of the treaty, so that anytime anything arises that concerns the interpretation or application of the treaty, that issue must be resolved by the CCJ. It is only the CCJ that has the competence to interpret the treaty. Somewhat surprisingly, there has been no referrals to date. I'm not sure whether this is because the domestic courts and lawyers alike are not sufficiently alert to the possibility, to the necessity for referring appropriate questions to the CCJ, or it may be that none has arisen. There was one case in Antigua when a journalist took the government of that country to court for unlawfully seeking to expel him from Antigua, and the issue was raised as to whether the matter should have been referred to the CCJ, but ultimately the judge decided that it should not be referred. Now, because states don't relish suing other states, much of the court's jurisdiction, almost all of the court's jurisprudence, has focused on the role, the status, the rights of private entities, individuals, and companies under the treaty. The court has actually concluded that the intent of the treaty itself was to give prominence to private entities in achieving the objectives of the CSME. This approach guarantees the progression, the development of the CSME from the ground up, so that there is a lot of scope for individuals, for companies to press for their rights before the court, and in this way to have the court pronounce on various issues, and so develop our understanding of the treaty and make people aware of their treaty rights. The court has therefore responded by encouraging private entities to be key players in the regime created by the treaty. A few examples will illustrate the point. The treaty, for example, in one of its articles, gives a right to private entities to have access to the court, and the way it's worded, it says, persons, natural or juridical, of a CARICOM state can have access to the court. Now, a question arose as to whether this means that the applicants, the persons who have access, must be, if in the case of a company that is under the control of CARICOM citizens, or whether when that issue came before the court decided that what it means is that it is sufficient for the company to be incorporated or registered in a CARICOM state, even if the company was not controlled by CARICOM citizens. So if a group of Japanese formed a company in Barbados and is registered in Barbados, and that company was producing something in Barbados, and they wanted to export that something to Jamaica, and Jamaica put up barriers, then that company could complain to the CCJ that if the barriers were in breach of the treaty, that this was a breach that the court needed to address. So it doesn't matter that the company was one that was owned and controlled by persons who are not from CARICOM. So that individuals who are not nationals, but who have, once they have a sufficient connection with a CARICOM state, they are entitled to approach the court and to seek relief. In keeping further with the ethos of promoting the role of private entities, the CCJ went so far as determining, in one case, that it was possible for an individual or a company to sue its own state before the Caribbean Court of Justice. And this was a little controversial because normally you expect that in international law, an individual or a company has a right to bring an action in place of their own state. And therefore, the idea of being able to sue your own state was somewhat odd. But we thought that it was important to give that right to citizens, nationals of individual states, because if we didn't do that, then it was possible that if you had a right of action against your own state, you would be debarred from bringing that right of action, whereas another person in CARICOM, if they had an identical right of action against that state, they would have the right to bring it. So you would be penalized by reason only of your nationality. And one of the provisions in the treaty is that there should be no discrimination on grounds of nationality only. The treaty regime seeks to encourage a situation where each national of each state should be treated in the same fashion, so far as enjoying the rights and benefits of the treaty are concerned. The treaty therefore permits private entities, individuals, and companies to institute proceedings in any case where their rights are prejudiced. But now, this is a little contradiction here, because in reality, the treaty rarely explicitly confers rights on these private entities. If you look at the Barbados Constitution, you would see a whole chapter devoted to fundamental rights of the citizen. The Revised Treaty of Chaguaramas does not have anything that resembles that. You would search the treaty and try to find, well, what are my rights under this treaty? And you would be hard-pressed to find ostensible rights that are conferred on individuals or companies. And so there's this little contradiction, because how can you give a right of access when a person's rights are prejudiced, but the very document in which you expect to find their rights set out, you don't see where those rights are? Well, the court overcame that contradiction by saying that, look, you don't have to explicitly find rights conferred on you in the treaty. What the treaty does is to impose obligations on states. And each time the treaty imposes an obligation on a state, every individual who can benefit from the implementation of that obligation has a right to the fruits of the following through, the implementation of that obligation. I wonder if you're understanding me. In other words, although you don't see anything saying that, well, you have the right to do this, you have the right to do that. The treaty, nevertheless, imposes obligations on states. It says states must allow freedom of entry to nationals of other countries. And so you have a correlative right. The flip side of the obligation is you have a right to freedom of movement. And so the court was able to extract the rights from the obligations. And this principle was applied in the cases that dealt, for example, with the common external tariff. The common external tariff is like a tax that you impose on goods that come into the region from outside the region. So that if we in the region are producing cement, for example, the Council on Trade and Economic Development will say that cement that is coming from Mexico or Dominican Republic will attract a 15% tariff, whereas cement that comes from the region will not attract any such tariff. And the idea is, the aim is to allow for locally produced goods to have a competitive advantage so that we can build up our local our local industries, and this all redounds to the benefit of CARICOM, although sometimes not so much to the consumer. But these are some of the sacrifices that we need to make as consumers in order for the greater good of the region to be realized. And we had a couple of cases with cement actually, where one state did not impose the common external tariff on cement, and so cheap cement was coming into that state, and the cement, the company in the Caribbean that was producing cement was finding it difficult to sell their cement in that country. And they complained to the court that the state was in breach of the treaty because they were not imposing the common external tariff on extra-regional cement. And we agreed with them that yes, you have a right to complain because the common external tariff is to your advantage as a producer of cement, and we ordered the country to impose the tariff on cement which was coming from outside the region. We did the same thing with another state in relation to flour. Suriname had been importing flour from Holland, its former colonial mother country, and there were flour producers in the region that were finding it difficult to sell their flour in Suriname because of this cheap flour coming in from Holland. And similarly, we held that yes, the flour producers had a right to complain, and they had a right to have Suriname impose the tariff on cement coming from outside the region, and we gave judgment accordingly. So in both of those cases, you see where on the basis of an obligation that is imposed on a state, a company that can extract a benefit from that obligation is able to claim a right and to come to court and to pursue that right. Now, how is a case filed in the original jurisdiction? Well, a private entity, whether individual or company, must first get permission or special leave from the court so that you don't just willy-nilly go and bring your case against whoever. You first have to go through a process where the court has to examine the claim that you are bringing and determine whether, in fact, it has merit and whether it should go forward. And in fact, we had one case from Barbados where a lady brought an action against a CARICOM institution called CARICAD. and we held that she should not get special leave to bring that action because, unfortunately for her, CARICAD was not an agent of the community, and nor was it a member state. You can only bring actions against member states or against the Caribbean community. And CARICAD was a body which, although it was an institution of CARICOM, it was not an organ or body of the community. Now, perhaps the most well-known case that the CCJ has tried has been the case of Shanique Myrie, which many of you would have been familiar with. This is a case of a young Jamaican lady who attempted to visit this country, ostensibly for a short vacation. And when she arrived at the airport, she was denied entry, detained overnight, and deported to Jamaica the following day. And she alleged that she was treated poorly. She was searched. She had a personal search done on her, and she complained about the denial of her rights under the treaty. And what's interesting about her claim is that it was not so much rooted in any particular provision of the treaty, but it was rooted in a provision of the treaty plus an agreement of the Conference of Heads of Government, a 2007 decision of the Conference of Heads of Government of the community taken at their 28th meeting. What the treaty did is to commit all CARICOM member states to the goal of free movement within the community. And the conference decision fleshed out the meaning of that free movement by providing details as to how free movement can and should be enjoyed by CARICOM nationals. In its defense to the action, Barbados denied the humiliating conduct the lady said she suffered, but justified the other treatment on the premise that Ms. Myrie had been untruthful about the identity of her Barbadian host. And Barbados also submitted that the 2007 conference decision did not create any legally binding rights. And so this was a case where there was a significant dispute about the facts as well as a dispute about the law. The court heard the testimonies from several witnesses in Jamaica and in Barbados, and the court was satisfied that the facts as alleged by Ms. Myrie were in the main established. The next question for determination was, well, what rights, if any, did CARICOM citizens have as a result of this 2007 conference decision? Now, as I said, this was a decision which was agreed, which was arrived at by CARICOM heads of government that on its face committed each state to permit CARICOM citizens an automatic stay in each other state for up to 6 months, subject only to the visitor not being an undesirable person or someone who is likely to become a charge on the public funds. All the available records suggested that this 2007 conference decision was always treated as valid and binding by the CARICOM Secretariat and by the various organs of the community. Barbados argued that Ms. Myrie's detention and her deportation could not be impugned because they were in keeping with the domestic law of Barbados. Barbados has an Immigration Act, and that Immigration Act sets out certain things. And the lawyers from Barbados said, well, look, according to this law, the lady was entitled to be deported. And so the issue arose as to how do you reconcile domestic law with treaty law when the two might be in conflict with each other. Well, the court didn't agree with the argument of Barbados. The court held that if ostensibly binding regional decisions could be invalidated at the community level by the failure on the part of a particular state to either legislate or to incorporate those decisions locally, then the efficacy of the whole regional structure will disappear, it will fall away, because it would mean that CARICOM leaders would be entitled to make agreements, publish those agreements to CARICOM nationals, and then if and when they please, they could simply renege on those agreements by saying, well, we agreed, but we didn't put that in our law. Or, yes, we agreed, but our law says something different. And the court took the view that this was not an appropriate way of going about building a community. That, in fact, if you want to become a member of CARICOM, if you join CARICOM, if you perceive the benefits of joining CARICOM, and there are benefits for each of the states. My favorite milk in Barbados is Pine Hill skim milk. And I'm sure that without CARICOM, there would be much cheaper skim milk in Trinidad that I could buy. So the point is that you're either in a community or you're not in it. And if you're in the community, then you have to be prepared to suffer the disadvantages as well as enjoy the advantages. So the court concluded that the 2007 conference decision was within the broader concept of freedom of movement of CARICOM nationals within the community, which is a goal to which each CARICOM state had expressly committed itself. And the court in those circumstances, the court found that Barbados was liable to Miss Myrie and ordered that damages be paid to her. I must say that those damages were in fact paid, and that matter was suitably resolved. In the course of giving its judgment, the court clarified practical aspects of the exercise of this right of free movement, and set out that where a community national is refused entry into a member state, as sometimes happens on legitimate grounds, then that national should be given the opportunity to consult an attorney or a consular official of his or her country, or to contact a family member. The refusing state must give promptly and in writing reasons for refusing entry, and must inform the community national of his or her rights to challenge the decision. Since refusal is an exception to the exercise of a right, the scope of the conditions on which a state could refuse entry, that is, undesirability or the risk of becoming a public charge, those grounds must be narrowly construed, and the burden of proof rests on the member state that seeks to invoke either ground. The Myrie decision broke new ground because it was the first occasion where an individual, as distinct from a company, a corporation, had obtained leave to institute proceedings. It was also the first occasion on which an applicant had been successful in obtaining a claim for damages, obtaining damages against a state that had been sued. And what the case did is to provide a very graphic example of how ordinary CARICOM citizens could invoke the court's original jurisdiction. So it allowed people to draw the link between this revised Treaty of Chaguaramas, which sometimes you think only lawyers know about or could read, or only governments and big companies seem to have any interest in. The case brought it home that this was a document not just for lawyers or for governments or for big companies. This was a treaty that had to do with the common man and woman of the Caribbean community. The case also provided a solid platform upon which regional governments could clarify and consolidate their commitment to freedom of movement. Now, the remedies and their enforcement, the remedies in the courts. Since the treaty does not contain any specific provisions relating to the remedies available to a litigant or the sanctions that may be imposed for breach of the treaty, there's nothing in the treaty that says, for example, that the court is allowed to give damages, or the court could only give a declaration, or the court could order a country to enact legislation, or what. The treaty does not go into any of these things. And therefore, it has been left to the court to develop this area of the law. In one of the cases, it was suggested that the court could only make declarations. That is to say, the court could listen to the complainant, listen to the state that is allegedly in breach, and then simply say at the end of the case that, well, we find that the state was in breach and it should put its house in order. And full stop. That was it. You know, there was a school of thought that the court ought not to go beyond this. The court brushed aside that notion. And the court stated that it was quite competent to go further and to make awards of damages, for example, as we did in Myrie, or indeed to order a state to impose a tax or to lift a tax. We could make coercive orders, in other words. And the court has done this. And in every single case, our judgments have been obeyed by CARICOM states. I told you in the case of Myrie, the government of Barbados paid the damages. In the case of Guyana and the cement, the government imposed the common external tariff on cement. In the case of Suriname and the flour from Holland, Suriname imposed the common external tariff on Dutch flour. We had another case in Guyana that had to do with an environmental levy that was charged on bottles coming into Guyana, but this levy wasn't charged on bottles being produced in Guyana. And we said, well, this is discriminatory. You cannot exact a levy on bottles coming in to Guyana from Suriname if you're not exacting the same levy on bottles being produced by Guyanese producers. And as a result, this was a company that was exporting soft drinks and other beverages to Guyana. And in order to sell their drinks in Guyana, Guyana required them to pay this environmental levy. And at the time when the case was before us, the amount of charges that the company had paid over a 6 or 7 year history amounted to over $6 million US. And they said, well, look, they kept paying these charges even though they knew it was unlawful because they wanted to remain in the Guyana market and so on. And we said, no, this was wrong, and that Guyana needed to refund this unlawfully imposed tax and to get rid of that law that required bottles from CARICOM states to face a levy which was not being faced by Guyanese bottle producers, like people who sold bottles, Guyanese that manufactured drinks in bottles in Guyana. And we went a step further in that case, Rhodesia, because we recognized that it was not enough, even though our judgments have all been obeyed, had all been obeyed up to that point, it was not enough simply to give a judgment, pass an order, and to think that our work was done, but that rather the court saw itself as having a responsibility to ensure that its orders were obeyed, and obeyed in a timely fashion. And so when we ordered Guyana to refund the money and to impose, to stop collecting this tax, we also set a date for the parties to come back before the court to report to the court on the progress that was made in complying with our order, so that if the order was not obeyed within that time, whether the Attorney General or whoever of Guyana in this case would have to come back to court and eyeball us and tell us, well, we didn't obey your order. Now, I know no Attorney General, Mr. Bradford will tell you, no Attorney General wants to be put in that position. And so, surprise, surprise, 2 days before the date, the parties announced to us that they had arrived at an amicable settlement of the dispute. So, some persons have expressed some concerns about whether in our original jurisdiction, the orders that we make, we're just like a toothless bulldog. That has not been the experience to date. And indeed, the Caribbean is a place where the rule of law is very well observed, and people obey the law not because they're forced to. People obey the law because it is the right thing to do. And I think that in our region, court orders are obeyed because, especially when governments are the judgment debtors, governments recognize that it is the right thing to do. So, to conclude, I would say that the existence of the CCJ and the jurisprudence that it has developed and is still developing have fundamentally altered the approach to regionalism in the Caribbean, because now Caribbean citizens are assured of the fact that when their leaders enter into agreements, when they make promises, that those promises will be obeyed. And if they're not obeyed, there is a tribunal to which an aggrieved party can go and get relief for any disadvantages suffered as a result of the failure to follow through on those agreements. And that is a fundamental departure from the CARICOM of old, where agreements were made and everybody went back home, never followed through with the agreements, and nobody was called to account. So that's pretty much what I would like to say about the CCJ in its original jurisdiction. I think that we are at a stage where a lot more can be done to deepen the integration process, but we are off to a very healthy start in putting in place mechanisms in order to assist that growth and development. To conclude, I want to again thank Monsignor Blackett for this opportunity to share with you, to congratulate him, as did Mr. Cave, on his 40th anniversary as an ordained priest,